Hello everyone, in this session we will learn the provisions of Amendment of Indian Constitution. However, before starting the topic, let us understand what is the meaning of an amendment. Basically, amendment in context of the provision of the Indian Constitution means modification of existing provision or provisions in terms of addition of new clause or clauses and or deletion of existing clause or clauses. Secondly, complete deletion of existing clause or clauses. Thirdly, addition of new provision or provisions. Likewise, amendment has basically these three meanings. Now let us begin with the quote of Pandit Nehru, who said, "If you make anything rigid and permanent, you stop a nation's growth, the growth of a living, vital, organic people." So, the makers of the Constitution made it flexible so that, depending upon the future condition, it may be amended. I believe by the time you people must be well aware with the significance of Amendment of Indian Constitution. Now let us begin with the introduction. The procedure of amendment in Indian Constitution is described in Part 20, Article 368. Only the Parliament has been given the power to amend the provisions of the Constitution. Indian Constitution has both the properties, that is, it is rigid as well as flexible. Article 368 empowered the Parliament to amend all the provisions of the Indian Constitution without any exception, but later some parts or provisions are excluded by introducing the concept of basic structure. Now, come to the types of amendment. Though Article 368 describes only two types of amendment, but actually it can be categorized in three ways as amendment by simple majority by the Parliament. It is not included in Article 368. Amendment by a special majority by the Parliament. Thirdly, amendment by a special majority by the Parliament and ratification by not less than one half of the state legislatures. Now let us discuss one by one. Amendment by simple majority by the Parliament. Article 368 doesn't define the amendment by simple majority. The provisions of amendment by simple majority is mentioned in other part of the Constitution. Article 4, Clause 1 interprets that the laws made under Article 2 or 3 to provide for the amendment of the first and the fourth schedules and supplemental, incidental and consequential matters. Further, Article 4, Clause 2 interprets that such law as aforesaid shall be deemed to be an amendment of this Constitution for the purpose of Article 368. Examples: a State Reorganization Act 1956 was passed by the simple majority in the Parliament. Case reference, that is Mangal Singh versus Union of India AIR 1967 SC 944. Now, the provisions amended by simple majority. Following are the provisions of the Indian Constitution. Those can be amended by simple majority. Article 2, admission or establishment of new states. Article 3, formation of new states and alteration of areas, boundaries or names of existing states. Article 3, formation of new states and alteration of areas, boundaries or names of existing states. Article 100, quorum of the Parliament. Article 169, abolition or creation of legislature councils in states. Some other provisions are citizenship, use of English language in the Parliament, procedure of the Parliament, salaries and allowance of the members of the Parliament. Now come to the amendment by a special majority. Following are the provisions of the Indian Constitution. Those can be amended by a special majority. Part 3rd, that is Article 12 to 35, Fundamental Rights. Part 4, Article 36 to 51, that is Directive Principle of State Policy. Part 4A, Article 51A, Fundamental Duties. Now, amendment by a special majority or parliament and ratification by at least one half of the state legislatures. Following are the provisions in the Indian Constitution. Those can be amended by a special majority of parliament and ratified by not less than one half of the state legislature. Provisions related to federal structure, that is Article 54, Election of President. Executive power of the Union and States, judiciary, representation of a state in parliament, provisions of Article 368, 7th schedule, etc. Now, come to the procedure of amendment. The procedure of an amendment of the Constitution can be initiated only by the introduction of a bill. The amendment bill can be introduced in either house of the parliament, either Rajya Sabha or Lok Sabha. The amendment right has been exclusively reserved for the parliament, hence it cannot be introduced or initiated by any state legislature. The amendment bill can be introduced by public member or members, that is minister or ministers, and private member or members, that is the member of parliament who doesn't hold any ministry. The amendment bill can be introduced directly, means it doesn't require prior permission of the president. The amendment bill must be passed by both the houses separately. The amendment bill must be passed by the special majority in each house separately. Regarding the amendment bill, there is no provision of joint session in the parliament. If there is discontent between the Rajya Sabha and Lok Sabha, the bill is considered to be rejected. If the amendment bill is seeking to amend the federal provisions of the Constitution, then the bill must be ratified by the legislatures not less than one half of the states. Once the amendment bill duly passed by the parliament and by the state legislatures, if required so, then it is being presented to the president, as the president's assent is mandatory. Unlike other bills, in reference to amendment bill, president has no right to withhold or return for reconsideration the amendment bill. He must give his assent. This mandatory clause was introduced by 24th Amendment 1971. This is all about the amendment in Indian Constitution. In my next session, I will be discussing the concept of basic structure.